God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
Good morning, Ms. Brown.
Commonwealth versus Kirwan.
Mr. Maidman?
Hey, Susan, after sample, I got to talk to you, so don't go in.
Good morning, Your Honors. If it please the Court. The Commonwealth's theory of first-degree murder in this case was based on deliberate premeditation. The premeditation was supposedly premised on testimony, at least largely premised on testimony, from one of the Commonwealth's witnesses, Brian Perry. The Commonwealth claimed that in its closing argument, the Commonwealth argued that the defendant told Mr. Perry that he went home to get his shank, shank being prison vernacular for a knife. The Commonwealth argued to the jury that the defendant told Perry, "I'm going home to get my shank." And they said he said it twice, and they said it was the most critical evidence in the entire case.
And actually, I take it the testimony was that he had said something about a shank.
That's correct. That's correct.
We
And
never got any more clarity than he said something about a shank.
That's correct. And it's on page 242 of Volume 2 of the transcript. And the point I would suggest from that is that
Well, whether he had said, "I'm going to get my shank," or if the Commonwealth had said he said something about a shank, what's the difference?
it was portrayed as actual testimony, as a quote.
Well, did the
It was
judge
not- I'm sorry, Your Honor.
did the judge tell the jury that what's said in final argument is not evidence?
He did. He gave what I believe were the standard instructions for closing arguments, that closing arguments are not evidence of the parties. But nonetheless, this was portrayed as actual testimony, and they hammered away at this in the closing argument. This was not portrayed as an imaginary or hypothetical conversation.
Did the defendant object?
No, there was no objection. Matter of fact, it's even worse than that. The defendant's lawyer, when he cross-examined this witness, incorporated the Commonwealth's misstatement to the evidence, saying, I'm not sure the exact words are, but basically he said, when you testified about him going home to get his knife. So he compounded the error. He did not object to the error, and the defendant also has alleged ineffective assistance of counsel. The problem is this was not a possible misstatement. The record is what it is, and the prejudice on this. This was essentially the Commonwealth portrayed this as this is the case where the guy went home in a barroom fight to get his knife, came back and stabbed the guy.
After saying something about a shank.
Something about a shank.
So he said something about a shank before the stabbing occurred.
That's correct.
So the question is whether or not he said, "I'm going home to get it," or he didn't say that. What difference does it make? If he was mindful of a shank, he was thinking about a knife, he made a statement indicating he was thinking about a knife before a stabbing. Isn't that the essence of the evidentiary value?
It was not immediately before the stabbing. It was at least an hour before the stabbing, maybe more.
It's worse, isn't it?
No, it's better. It certainly was not on the forefront of his mind. Also, the evidence it's clear in the record that at the end of the night, this guy was walking home. It turns out he lived across the street.
But weren't there episodes between him and Perry?
At least 5 episodes, depending on how you count them.
And the statement about the knife or the shank occurred after the first episode.
It was after the second episode.
Okay.
It was after the second episode. But there were problems with another guy, a guy in the bar. There were 2 guys. And the defendant was clearly provoked. I mean, I don't think that there's any real argument that provocation was not involved in some form. Repeated provocation. At the end of the night, the defendant is walking home to his house diagonally, right across the street to his house, and the victim pulls up, and basically there are words between them, and then he gets out of the car, and then there's the altercation on the side of the road, which moves into the center of the road. This was a barroom fight. I mean,
Well, the description of the altercation is that the victim isn't throwing any punches.
That's a rather one-sided altercation.
There's conflicting testimony on that about whether there was shoving or not. I understand what you're saying, and that is in the record, but it's not that clear just what was going on. But you're correct, Your Honor. The other thing I want to emphasize is that this was not presented to the jury as a hypothetical conversation, an imaginary conversation. This was presented as the actual the actual testimony, and it would have been very difficult for the jury to sort out the error.
How many days of trial? How many days of trial? This was not a long trial.
No, it was not a long trial. It was.
So the jury is not forgetting on day 4 what the testimony was on day 2.
Right. It was, my recollection is 3 or 4 days, and the jury verdict came back very quickly also, which I would argue was a product of the Commonwealth's overstatement, misstatement of what actually transpired in the trial. If there are no other questions, I'll move on to my second issue.
If the jury had taken a long time to return a verdict, you'd be arguing that they would have acquitted him but for the statement.
Probably, Your Honor.
So
probably, but
time to the verdict doesn't seem to me to mean very much. Anyway, say la vie. What's the next issue?
The next issue was the defendant's his closing argument, the counsel's closing argument, and the claimed error there is that the defendant did not concede the patently obvious that he stabbed the victim. The evidence was overwhelming that he stabbed the victim. There was no one else. There was no one else near the defendant at the time. And when you read the closing argument, it's almost as if he did not expressly deny that he stabbed the victim, but he was just about a denial. And his theory of the case, the defense theory of the case was self-defense or excuse by self-defense or mitigating circumstances based on provocation, being sudden combat,
dispute in the bar.
Right. The three different theories. And the jury was instructed on all three.
What's so bad about that?
The jurors would have been there wondering, when is this defendant going to concede that he did it? How can you have a self-defense case if you do not admit that you committed the act which resulted in the crime? That never happened in this case.
And you say it should have happened.
Absolutely. There was no strategic reason why it shouldn't have happened in this case. Let me briefly touch on a couple other issues in my remaining time. There was the prosecutor's comment on the prison movie. When Mr. Perry was testifying, I think a fair reading of that direct testimony was that he was frustrated that he could not get the witness to say that he was going home, that he went home to get his knife. So he ends it by saying, because the witness had said, I had a lot to drink. I just like to just mention something about a shank. I didn't even know what it was. The Commonwealth says, have you ever seen a prison movie? We spend a great deal of time in the courts in this Commonwealth sanitizing mug shots, dealing with whether prior convictions are prejudicial, and then here we have prison comments.
Well, objection was made and was sustained, was it not?
The objection was sustained, but there was no motion to strike. There was no curative instruction.
By the way, and the question is to Perry. It's not about the defendant having seen a prison movie.
It's about seeing a movie, not being in prison.
The implication a juror could imply from this, that this defendant, because he used the word shank, was a seasoned veteran of the criminal justice system in some fashion. Some kind of a curative instruction should...
The suggestion is that this is terminology that you can pick up from movies. And the sense I get, obviously, just from the transcript or the portions quoted in the brief, is that the prosecutor is suggesting that ignorance of what the term shank refers to is somewhat incredible because everybody knows it from prison movies.
It could be read that way, Your
That's
Honor.
the sense I get.
Could be read that way. It could also be read implying that the defendant had a criminal record in this case. It turns out, and this is evidence in the record, that the defendant did not have he had a top secret security clearance. He was formerly employed by the National Security Agency. There were no, I don't believe any prior convictions were introduced in the record. The humane practice instruction, there was no humane practice instruction in this case. I would suggest to the Court that it was that intoxication, the defendant's intoxication, let alone the intoxication of various witnesses in the case, was a live issue in the case. And at one point, the Commonwealth, to deal with that live issue, the Commonwealth tried to introduce the booking tape to show ostensibly that the defendant was not drunk. The problem was there was an objection to that because the booking tape was made a number of hours after the actual statements were made to the police. Another issue in the case is whether the defendant was entitled to Miranda rights when he was interviewed by the police at his house. There were no Miranda rights prior to the statements. Judge Chin found that the statements were, it was interrogation, but it was not custodial. The problem is that this statement was this interrogation was designed to elicit incriminating statements. Matter of fact, it began by the exact words are in a footnote in my brief, but it was words to the effect, "Well, tell me about the fight you were just in at the bar across the street." This was not, "Were you there? Are you the person who was there?" This was clearly designed. The words the officer testified to this. The words were clearly intended to elicit an incriminating statement, and he should have been Mirandized. I'd like to use the last few moments of my time to make a brief argument on verdict reduction in accordance with Section 33E. Your Honors, I think the record fairly reflects that this was a fight outside a bar. The defendant was provoked. He was provoked at least 5 times by this particular victim. He was provoked by other victims. Virtually everybody was, if not intoxicated, under the influence within the meaning of the law. They were at least, there was lots and lots and lots of alcohol. The defendant was walking home just prior to this incident occurring. And in combination with all of the errors which I've suggested to this Court in the brief, I would ask you to take a look at what actually happened. I think that this was not premeditated. I would suggest, Court, it's not premeditated murder. It's something else. And I would ask the Court to carefully consider that. And with that, I would rest on my brief.
Thank you, Mr. Maidman. Ms. Burbine?
May it please the Court, Carolyn Burbine for the Commonwealth. The prosecutor did not create a substantial likelihood of a miscarriage of justice in his closing argument. All of this was supported by the record.
Those really was a fair inference from the
evidence. It was a very fair inference because we actually...
He said something about a shank, so, prosecutor could say he was going home to get the shank.
Exactly, and we have more than just...
Because he went home.
Yes, and we have more than just saying something about a shank. He said he was worried about... I'm sorry. He said he was worried about wanting to pick up a shank or something like that, and then he left the bar. So we have a reasonable inference here. Clearly. And indeed, what did happen was he made that statement, he left the bar, he came back, and subsequently he did stab the victim. And so it's a reasonable inference that from those statements by Mr. Perry, that was the defendant's intent, and indeed he did carry it out. And even if there had been any kind of error, the judge's instructions would have covered it. He instructed the jury in preliminary and final instructions that the closings are only to assist them and that they are to determine the evidence and decide what evidence is relevant and what they will accept.
I have 2 questions. On what theories of murder were the jury instructed?
First degree.
On premeditation.
Premeditation.
Were they also
definitely
instructed?
Premeditation.
And they were not instructed on extreme atrocity?
No.
Okay, so it was just
Premeditation.
premeditation. And the second question I have is, what was the thrust of the defense closing argument on the question of premeditation?
He was, I'm sorry, he was relying on that the defendant was provoked and just protecting himself against an aggressive revenge-seeking victim.
The defense
that's
was
how I
really, he was
characterize
looking
it.
for a manslaughter verdict.
He was looking for
wasn't he?
manslaughter.
You know, the typical barroom brawl, a barroom incident that got out of hand, you know, provoked and all this and that.
Right, it was
Girlfriend
self-defense
troubles.
or provocation.
Did he address the issue of the shank at all?
I don't believe he did. I can't recall exactly, but I don't believe that he did address it.
He couldn't do much with that, could he? Because that was the testimony. And
I think he was, I mean, he was
the guy
clearly
went home
stuck
and
with
they
it.
They did find the knife
Right.
in his apartment or house or whatever it was.
It was found between the house and the bar. The house was
Yeah.
across the street from the bar. And also, Judge Tin noted that in his findings rejecting the defendant's motion for new trial, that defense counsel had actually asked Mr. Perry a question now, and within that question he said, you had testified that he went home to get a shank, and then continued the question, and then Perry answered the question, and Perry never said, I didn't say he didn't go to get a shank. So I think that it's a readily available inference, and it certainly was not reversible error. As far as the defendant's closing, I think that there was no error in his arguing through the facts for manslaughter. He doesn't have to explicitly come out and say, I urge you to find manslaughter. I mean, everything that he said pointed toward it. He emphasized that the victim was the one that kept coming up to the defendant and urging and starting the arguments, and that it just doesn't seem that he ignored this manslaughter at all. He stressed it in his final argument, and it's clearly there, and that's what Judge Chin found as well. The prison movie question, I just would say anyone who heard that question would know that it referred to someone who'd seen a prison movie, might know the jargon. And the judge the objection was sustained, and that should be the end of it. Did the court have any questions on any of the other issues? I would be content to rest on my brief.
Thank you, Ms.
Thank you,
Burbank.
Your Honors.